Greetings from Bharat Institute of Law. Myself, Archana, Assistant Professor, Bharat Institute of Law, Bharat Institute of Higher Education and Research. In this session, we'll be dealing with an overview of Water Act 1974. This is a topic from environmental law. In this session, we will be dealing with the salient features of Water Act 1974, which includes some important definitions provided under this Act, establishment of Central Pollution Control Board and State Pollution Control Boards, their functions and powers. We will also be dealing with the methods adopted by the legislature as provided under this Act to deal with water pollution and the penalties for non-compliance of the provisions of this Act. Further, we will also be dealing with a case law relating to water pollution. Now, let's move into the session. The original title of Water Act is the Water Prevention and Control of Pollution Act 1974. The title of this Act itself suggests the purpose of this very Act. So the purpose, the main objective or the main purpose of this particular Act is to prevent and control pollution of water. So when this Act was enacted in 1974, the intention of the legislature was to prevent and control water pollution. Since 1974, the Act was amended only once, and it was in the year 1988. This Act has also got a set of rules, that is the Water Prevention and Control of Pollution Rules of 1975. The Act came into force in 1974 and the set of rules attached to this particular Act came into force in 1975. Even though the primary objective of this Act was to prevent and control water pollution, it had some other reasons also for the enactment of this particular Act. Those reasons include fast decreasing per capita availability of water and increasing pollution of existing water supplies and the fast increasing use of water for irrigation, etc. This Act, in its statement of objective, provides that this Act was enacted for providing for the prevention and control of water pollution and to maintain and restore the wholesomeness of water. Apparently, it is very clear that the very objective of this particular Act was to prevent and control water pollution. Now, the question is, what was the intention of the legislature when it meant prevention and control of pollution, and how the same can be done? So, the legislature came up with this idea for establishment of pollution control boards, which can ensure prevention and control of pollution. Again, to prevent and control water pollution, this Act also provided for different set of acts which are considered as an offense and provided for penalties for whoever committed those acts. So, two broad methods were adopted by the legislature through this Act. One is the establishment of Pollution Control Board, which will monitor the activities at central and state level, and it provided for punishment for those who basically committed pollution. Now, let us see from where the Parliament derived its power to legislate this particular act. Water is basically a subject matter of state list, but the Water Act of 1974 is a central legislation. But Parliament derived its power to legislate on this subject matter from Article 252 of Indian Constitution. Article 252 deals with the power of the Parliament to legislate for two or more states by consent and adoption of such legislation by any other state. So, if you see section 1 of this particular act, it would state which all states have adopted this particular law. However, it is interesting to note that all the states would have adopted this particular act. Apart from Article 252, the Parliament also has the power to regulate interstate water under List 1 of Schedule 7, Entry 56. So basically, pollution is not something that is limited to the water bodies of any one particular state. Pollution is caused to rivers that flow from one state to another state. Hence, the enactment of this particular act, the Water Prevention and Control of Pollution Act 1974, is well within the legislative powers of the Parliament. We have already seen what are the primary objectives of enactment of Water Act 1974. Now, let's deal in detail with the other objectives of this particular act. I repeat it again that the main or the primary purpose of this act was to prevent and control water pollution, to maintain wholesomeness of water. So what is meant by wholesomeness of water is to maintain the quality of water so that its consumption and use by living organism is not hampered. To put it simply, to ensure that water is available to living beings at consumable quality. So, the other objective of this act was to maintain the consumable quality of water. Another objective of this act was to establish state pollution control boards at the state level and central pollution control board at the central level, and to vest them with various powers that will enable these boards to take steps against control and prevention of water pollution. One thing that can be noted here is that when in 1981 the Air Act, that is the Air Prevention and Control of Pollution Act, was enacted, these state pollution control boards and central pollution control board was vested with the power to take steps for prevention and control of air pollution also. So basically the scope of this particular boards, State Pollution Control Boards and Central Pollution Control Board, was expanded. This Act also provided for certain measures that can be adopted in order to prevent and control water pollution. Subsequently, this Act also provides for penalties for non-compliance of those provisions of the Act. So, any non-compliance of the provisions of the Act has been considered as an offence, and the Act in itself provided for penalties for such offences. Another important objective of this Act was to establish water testing laboratories at state and central level. The main function of this laboratory is to test the quality of water from different water bodies. Let's suppose there is a factory that is functioning on the banks of a river, and the effluents from the factory goes to that particular river. Taking into consideration the self-cleansing ability of water, the Pollution Control Boards itself has prescribed a limit on the amount of effluents that can be released into water body by a factory. So how this is checked? Whether the factory is releasing the effluents in the prescribed limited quantity. So this test is done by the state laboratories. If the permissible limit is not followed by the particular factory, then it is considered as an offense under this particular act. So these are the objective of the Water Act 1974. Now let us see what are the salient features of the Water Act 1974. The Act has been divided into 64 sections compiled in 8 different chapters. Section 2 of this particular Act, like any other Act, deals with the definition part. Section 2 defines 11 terms including water pollution, sewage effluent, sewer, stream, trade effluent, etc. The important definitions that are to be considered here is that of water pollution, sewage effluent, and trade effluent. Water pollution under this Act has been defined as such contamination of water or such alteration of the physical, chemical, or biological properties of water, or such discharge of any sewage or trade effluent, or of any other liquid, gaseous, or solid substance into water, whether directly or indirectly, as may or is likely to create a nuisance or render such water harmful or injurious to public health or safety, or to domestic, commercial, industrial, agricultural, or other legitimate uses, or to the life and health of animals or plants or of aquatic organisms. To put it in simple words, any act that changes or alters the feature of a water body by discharging something into the water which can cause any nuisance or which can cause some harm to the people, animals or plants. So that is what is called as water pollution. Another important definition that need to be considered is of stream. In general sense, stream is basically a small water body. But under this act, stream means a lot of other things. Stream includes a river, any water course, whether flowing or being in a dry state, any inland water, whether it is natural or artificial, any subterranean waters, that is the underground water, and sea or tidal water. So all these water bodies are generally termed as stream under this particular act. The next definition that need to be considered is of sewage effluent and trade effluent. So basically, sewage effluent is the domestic effluent and trade effluent is basically the industry or factory based effluents. This particular act defines sewage effluents as effluent from any sewerage system or sewage disposal work and includes sullage from open drains also. So the difference of domestic and industrial waste is understood from the definition of trade effluent, whereas trade effluent has been defined as any liquid, gaseous or solid substance which is discharged from any purpose, any premises used for carrying on any industry, operation or process or treatment and disposal system other than domestic sewage. So, the definition of trade effluent clearly helps us to understand the difference between domestic sewage and industrial sewage. So these are the important definitions under this particular act. Section 3 and Section 4 of Water Act provides for constitution of the Central Pollution Control Board at the central level and state pollution control boards at the state level. Chapter 2 of this particular act, which deals with Section 3 to Section 12, provides for the constitution of pollution control boards, terms and conditions of the service of members of this particular board, power of the pollution control boards to constitute committees, powers of the pollution control boards to get into association with experts for temporary purposes, appointment of other staffs by the members of the pollution control boards, etc. As the establishment of these boards were one of the primary objective of this particular act, the establishment and constitution of this particular boards are dealt in detail under this act. So, Section 3 to Section 12 deals with the establishment and constitution of pollution control boards. Chapter 3, consisting of section 13, 14 and 15, provides for constitution of joint boards by states and its composition. So there is one pollution control board at the central level, which is in New Delhi, and every state has a state pollution control board. When this act was enacted, section 13, 14 and 15 provided for establishment of joint boards by states. That is, two neighborhood states can come together and form one state pollution control board for both the states. The said provisions deals in detail about how such joint state pollution control boards can be formed by two or more states together. However, it is to be noted that there are no joint boards in India. Every single state has a state pollution control board on its own. So basically, there are 29 state pollution control boards in India. Section 16, 17 and 18 under Chapter 4 deals with functions and powers of the Central Pollution Control Board and State Pollution Control Boards. Some of the major functions of the Central Pollution Control Board includes advising the central government on any matter concerning the prevention and control of water pollution, coordinating the activities of the state pollution control boards, providing technical assistance and guidance to the state pollution control boards, plan and organize training of persons engaged or to be engaged in the programs for prevention and control of water pollution, and organize through mass media a comprehensive program regarding the prevention and control of water pollution, etc. Some of the major functions of State Pollution Control Board includes advising the state government on any matter concerning the prevention control of water pollution, to collect and disseminate information relating to water pollution and prevention and control thereof, and to encourage, conduct and participate in investigations and research relating to problems of water pollution and prevention and control of the same, and to collaborate with Central Pollution Control Board in organizing the training programs for people engaged in various programs related to prevention and control of water pollution, to inspect the sewage or trade effluents, works and plans for the treatment of sewage and trade effluents, and to review those plans, specifications or other data relating to the plans that has been set up for the treatment of water, etc. Chapter 5, which includes section 19 to 33A, is one important chapter under this Act, which provides for the methods that can be adopted by the central government, the Central Pollution Control Board, the state government and state pollution control boards to prevent and control water pollution. It basically vests with the central and state government and central and state pollution control boards with certain powers in relation to control and prevention of water pollution. Chapter 6 of this particular Act deals with the funds, accounts and audit of the state pollution control boards and central Pollution Control Board. Basically, the contributions to the funds of these boards are made by the state government and central government. Apart from the annual financial contributions made by the state government to the State Pollution Control Board and the central government to the Central Pollution Control Board, the boards are also having the power to borrow funds through loans or through issue of bonds, etc. This chapter also provides, or rather mandates, that these pollution control boards has to submit an annual report and has to do an annual audit, and the accounts and audit has to be maintained regularly by the boards. The next important chapter under this act is of penalties. Chapter 7, which includes section 41 to 50, provides for different acts that are considered as offences under this act and the penalties for the same. Penalties under this act not only include fine but also imprisonment. Under section 24 of the act, use of stream or well for disposal of any polluting matter is prohibited. So this is an act that is considered as an offence. The penalty for the same has been provided under section 43, which says that whoever contravenes the provision of section 24 shall be punishable with an imprisonment for a term which shall not be less than 1 year and 6 months, but which may extend to 6 years and with fine. Likewise, there are certain provisions which has been dealt previously and the penalty for the same has been provided under the Penalties Chapter. Apart from that, the Penalties Chapter also provides for certain set of acts which are considered as offence specifically under section 42. Chapter 8 is the miscellaneous chapter and it goes from section 51 to section 64. The establishment of Central Water Laboratory and State Water Laboratory has been provided under this chapter. The Central Water Laboratory is to be established by the central government by notification in the official gazette, and the State Water Laboratory has to be established by the state government by notification in the official gazette. Apart from the establishment of laboratories, this chapter also provides for appointment of analysts. The central government can appoint analyst to the central laboratory and the state government can appoint analyst to the state laboratories. Basically, analysts are the person who are appointed for the purpose of analysis of water or of sewage or trade effluent sent for analysis to any laboratory, that is state laboratory or central laboratory. Miscellaneous chapter also provides for the power of central government and state government to make rules relating to different subject matters. That's all with the salient features of the Act. In some other session, we will discuss in detail about the methods adopted under this Act to prevent and control water pollution and what are the penalties for the non-compliance of certain provisions of this Act that deal with methods of control and prevention of water pollution. MC Mehta versus Union of India is one of the landmark judgments relating to water pollution. This particular case is famously known as Ganga pollution case. In this case, A writ was filed to prevent the leather tanneries near Kanpur from disposing of the domestic and industrial waste and effluents into the Ganga River. One important observation that was made in this particular case was of the failure of the State Pollution Control Board in taking steps against the company that was not complying with the provisions of the Water Act. It also observed the effect or impact of discharging waste to the Ganga River. An order was passed for setting up of effluent water treatment plant and also ordered for closure of the tanneries until the said treatment plants were set up. That's all with this session. Thank you.